My name is Tae-Ming Hong. I will be presenting on historical context of modern treaty-making concept of public international law. A treaty is a written agreement between sovereign states and in some cases international organizations which formally signed by their leaders and is binding at international law. An agreement between states will not be a treaty unless those countries intend the document to be binding at international law. The rules concerning treaties between states are contained in Vienna Convention on the Law of Treaties 1969. The Vienna Convention in Article 2, Clause 1, Clause A defines a treaty as an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or two or more related instruments, and whether its particular designation. Treaties can be classified into two types, which are bilateral and multilateral treaties. A bilateral treaty is a treaty between two parties, because only two states need to agree. States use bilateral treaties to conduct direct affairs with a foreign nation. A multilateral treaty, in contrast, is a treaty signed between three or more states. Such treaties can include agreements between states in a particular region, or agreements by most or all of the states in the world created to address a global issue. Multilateral treaties are an advantageous way for states to make joint commitments to a particular issues. Treaty formation involves four steps, namely negotiation and drafting, authentication and adoption, expressing consent, and entry into force. The Vienna Convention on the Law of Treaty provides guidance on each of the process works. First, parties must come together to negotiate or to discuss a treaty topic. Drafting involves putting the tentative terms of an agreement in writing. Next, once all parties have settled on final terms, they move to treaty adoption, in which parties agree on the official treaty text. Treaty authentication is the process in which each party signs or initials the treaty text to establish that the text is final. Once treaty authentication is complete, states can then bind themselves to the treaty by expressing their consent. The consent of a state may be expressed by signature, exchange of instruments, constituting a treaty, ratification, acceptance, approval, or accessions, or by another means if so agreed. Once one party expresses its consent to be bound by a treaty terms, the treaty still needs to take formal legal effect. This is known as a treaty entry into force. Accordingly, such a treaty often provides that it shall enter into force when it has been ratified or acceded to by a specific number of states.
Very good day to Dr. Su. My name is Clifford and I will be discussing on the difference between ratification, reservation, understanding of memorandum, and declaration. A memorandum of understanding is an international agreement, but the wordings of the memorandum is construed in order to express an intention for the agreement to be binding in international law context. A memorandum of understanding is used when the parties to the agreement had the intention to remove any formalities of it being a treaty. This can happen when the nature of the agreement involves in provisions that are not permanent and constantly changing, or if the provisions of the agreement is required to be confidential for the protection of national security, such as matters of defense or technology, where such information must be regarded as classified information. For ratification, ratification is often required as a symbol of approval or mutual acceptance of the said treaty between the parties to the treaty. Legislation must be enacted before the treaty can be ratified. It is important that the enforcement of the legislation shall be made before the treaty is ratified and comes into force within the state. It is important for the state to be fully prepared and is in the position to exercise the treaty before the treaty is given effect within the state. Otherwise, it will impose a risk of breach of its international obligations. For reservation, Article 2, Clause 1 of the Vienna Convention explains that a reservation is the exclusion of the legal effects on certain provisions within a treaty when signing or ratifying a treaty. There are different types of reservations. A disguised reservation is where the word reservation was not used and were replaced by other words such as understandings, explanations, or observations. Another type of reservation is interpretative declaration, where in cases of differences in opinion in a multilateral treaty, a delegation may be made to interpret the statement as to favor the domestic law of the states concerned. For a declaration is a legal document that is not legally binding but serves as a guide on the commitment of being a member of the declaration. Declarations are mostly interpretations from the resolutions of a General Assembly.
My name is Taiyu, and I will be presenting on how reservations serve a useful purpose for a state and the examples from the US and Malaysian perspective to different treaties. A reservation is a declaration by a state made upon signing or ratifying a treaty. It signifies that the state has the right to not abide to certain principles laid down in the article of the ratified treaty. A reservation allows participation in treaties by states that generally agree with the overall idea of the treaty but are unable to accept some of its provisions. It is a tool used by the reserving state to modify its obligations under the treaty in order to be in line with its domestic law under political, cultural, or social reasons. Malaysia has made reservations to Article 9.2 and Article 16.1a, c, f, and g of the CEDAW. These reservations were made as they were considered as not in line with the Malaysian Federal Constitution, Islamic law, and national policies. And Malaysia aims to preserve its Islamic identity and also to ensure the human rights of women are safeguarded under the Islamic law. This can also be justified as Malaysia is a multi-ethnic country. Besides, Article 3.1 of the Federal Constitution states that Islam is the religion of the Federation. Hence, the Muslims in Malaysia are required to obey the teachings of Islam in their life. As for the Convention on the Rights of the Child, Malaysia has made reservations to Article 2, 7, 14, 21.8.1a, and 37. Malaysia declares that these provisions shall be applicable only if they are in accordance with the Constitution, domestic laws, and national policies. As for the United States, the US has made several reservations to the ICCPR. For example, is Article 20. And the US Senate has made a reservation stating Article 20 does not restrict the freedom of speech and association that is guaranteed under the Constitution of the United States. The position of the United States is that when a provision of a treaty is in conflict with the Constitution, the principles in the Constitution shall prevail in the end. The US has also made a reservation to Article 6.5 of the ICCPR to conserve the power to impose death penalties on the juvenile delinquents. The US has also made reservations to the Genocide Convention. The first reservation was made to exempt the US from jurisdiction of the International Court of Justice. The second reservation was made to signify that the US would not adhere by the convention to take an action that is forbidden by the US Constitution. So, as a conclusion, the attitude of the US towards the usage of reservations can be explained by the concept of the American exceptionalism.
Good day, Dr. Su. My name is Cindy Linianqi, and now I'll be presenting on issues relating to reservations based on the Human Rights Committee's General Comment number 24. So, what are the criteria of an acceptable reservation? We shall ascertain this by applying the object and purpose test. By virtue of Article 19 of the Vienna Convention on the Law of Treaties, a state may make a reservation so long that it is not incompatible with the object and purpose of the treaty. In the Genocide Convention case, also known as Bosnia and Herzegovina against Yugoslavia, it was said that the states had intended white participation, and so the reservations should not oppose the object and purpose of the treaty. In advisory opinion on reservations to the Convention on the Prevention and Punishment of the Crime of Genocide, the issue was whether the reserving state can be regarded as a party to the Convention if its reservation is objected by one or more of the parties to the Convention. It was said that even if the reservation is objected by one or more parties to the Convention, so long that the reservation is compatible with the object and purpose of the Convention, the reserving state can still be a party to the said Convention. In British Yearbook of International Law 1967, Borward said that the acceptability of a reservation is independent on reactions of the states to the Convention. In the case of Belilos and Switzerland, it was said that the reservation was invalid even without objections by state parties to the treaty. It was held that the Swiss Interpretative Declaration concerning Article 6 of the European Convention on Human Rights (ECHR) was a reservation, but it was invalid due to its wide scope within the requirement of Article 64 of the ECHR. Now I'll be talking about unacceptable reservations. Unacceptable reservations are reservations that are not compatible with the object and purpose of the treaty. In the Nicaragua case, it was held that self-judging reservations were invalid. The ICJ in the advisory opinion on reservations to the Genocide Convention said that there must be a balance between interests of a state and the object and purpose of the Genocide Convention. Article 19 of the Vienna Convention provides 3 circumstances that may render a reservation unacceptable. And in the case of Raw and Kennedy and Trinidad and Tobago, it was said that despite the reservation, complaint could still be done. Reservation that sought out a certain group of individuals for lesser procedural protection is not accepted by the committee. That's all from me. Thank you.
My name is Chua Keng Zhen. I will now discuss about the consequences of an unacceptable reservation. The first reservation is the surgical doctrine, would give the state the benefit of its reservation even though the reservation is entirely compatible with the object and purpose of the treaty. This consequence would stand against the purpose of Article 19C of the Vienna Convention on the Law of Treaties 1969. This doctrine would bring an objectionable result and it was generally not accepted. The second consequence of an unaccepted reservation can be explained by the Bankless Doctrine. The general principle is that a state needs to give its consent in order to be bound by an international law instrument. Since a reservation denotes the circumstances where a state will give its consent to adhere to a treaty, it will go against this principle. Some scholars contended that an incompatible reservation will invalidate the state's acceptance of the treaty. The justification behind is that the state's commitment to be bound by a treaty is outweighed by its willingness to make an incompatible reservation to its ratification of a treaty. In reality, there are few objecting states or international organizations who view the reserving states as not bound by the treaty in such circumstance. Last but not least, the third consequence of an unaccepted reservation will be referred to as the Rehability Doctrine. The doctrine is the solution that is mentioned in the HRC comment. This doctrine leaves the state as a party to the treaty without being benefited by their reservation. It protects the state's membership to the treaty while still preserving the principle of state consent. This doctrine would benefit both the reserving state and the international human rights organization. The reserving state can maintain its membership to the treaty and its human rights protection is enhanced. Democratic states would more prefer that their incompatible reservations to be severed rather than to lose its membership to a treaty. That's all for question 4, and I will now discuss about a bonus question which I have to invent a quote and explain it. The quote is, "I do not think that the international human rights treaties improve respect for human rights and they certainly need a review and amendment." The explanation to the quote is that since the inception of the Universal Declaration of Human Rights, many international law instruments such as treaties have been made. It was criticized that these international law instruments have not brought significant changes in reality. Some argue that these international laws can only improve respect for human rights. Instead, they are democratic and have a civilized society dedicated to human rights. In autocratic countries with a less civilized society, ratification of treaties have no effect, and it is even linked with increased human rights violation. Some countries ratify treaties without having the intention to really improve its human rights condition. Treaty ratification is more helpful if the country has stronger civil society and its people engage in international non-government organizations. This phenomenon creates findings that support liberal theories and the theory of transnational human rights advocacy networks. There are only a few situations where treaty ratification has unconditional helpful outcome on human rights. In many instances, a treaty ratification will be helpful if its citizens and society have the power to persuade and pressure the government to elevate its human rights potential. That's all from me. Thank you.